all not adequately training law students in areas of IP law, and until very recently again, with very few honorable exceptions, law schools not receiving by students, things are changing. Loss of faith of ordinary people and consumers of justice, judicial process. I'm sorry to move a bit fast because time is running out. From customs point of view, this is mostly prior to intellectual property rights, imported goods enforcement rules. Many of the issues here have been duly addressed there. Lack of awareness of custom officials, burden of proof remains solely on the right holder. No specific statutory provision with respect to a period within customs, within which customs must act based on the request of the right holder. That has been addressed properly. So some more issues, but has been addressed. Police. Lack of awareness of the police officials regarding intellectual property rights. Manpower shortages, that's a huge issue. Force the focus of attention to life-threatening issues and violent crimes naturally. To complicate matters, only officers at the senior levels are allowed to conduct raids. Finally, officers participating in the raids are not trained to identify counterfeit items. So, a total paradigm shift necessary in all sectors. Now, everything is not bleak. There are some rays of hope as well. So, I will refer to some landmark judgments issued by the judiciary at a time when our laws are not even thrift compliant, to show our judicial prudence, but that has to be increased. Doctrine of transport reputation, I'll just grab through because time is really running out. This is doctrine of transport reputation, whether goodwill in trademark 7 o'clock stood extinguished because of non-availability of blades with the mark in India after 1958. The division bench turned down the claim. It said no. Just because it is not available in India doesn't mean that it doesn't have a transport reputation. The observation is very nice, but I'm not going into the detail. There is another Whirlpool case. The case is recognized that the reputation of the trader trading or carrying on business in another country can travel to a country where he had carried no business. The trader's transport reputation can be on the basis of extensive advertisement and publicity. Such a trader could obtain injunction by courts where he was not trading to protect his reputation. Very rightly so, doctrine of passing on has been upheld. To refer a case in a Dongri Whirlpool, which is a very famous case, you can see when it was issued 1995, going back to 1995. The concept and principle on which passing of action is grounded is that no man has any right to represent his goods as the goods of another. The trader needs protection of his right of prior user of a trademark trade name as the benefit of the name, fame, reputation, and image and goodwill earned by him cannot be taken advantage of by another trader by passing on his goods as those of the prior user of the trademark or trade name. Doctrine of dilution. I have a panelist here, the famous Baines case. Everybody knows it. Just to refer to from the observation, in the instant case, Baines is a name given to a very high-priced and extremely well-engineered product. In my view, the defendant cannot dilute that by use of the name Baines with respect to the product like underwear. So that's amazing. Meaning of imports in copyrights, there has been a big debate on the issue of whether goods in transit can say to be imports. It went up to Supreme Court when the Supreme Court held that the word import in section 51 and 53 of the Copyright Act means bringing into India from outside India. It is not limited to importation for commerce only, but it includes importation for transit across the country. That's a huge, huge charge. Pecuniary penalties awarded, which is still not the norm, but there are precedents showing that even damages, punitive damages to the, Punitive damages to the tune of 5 lakhs have been granted, and so far damages of 19 lakhs 75,000 rupees have been granted so far. So, Indian courts have granted damages with punitive damages. Changing the judicial strict dealing with violations, increasingly looking at the underlying principles of intellectual property law and global precedents. If specific protection provisions in Indian law are absent, increasingly appreciating that national boundaries have faded commercially and international brand reputation and goodwill have spilled over to India. Doctrine of dilution has been distinguished as an independent doctrine. So, at the government level, to talk about the initiatives, yes, there are state-of-the-art IP offices, digitization of IP database, interactive guidances, National Institute for Intellectual Property Management, National Police Academy. The government also brought out a handbook for copyright law that will distribute at free. Department of Education and Ministry constituted Copyright Enforcement Advisory Council. Things so in and so forth. In the industry level, government efforts well compensated by strong industry initiatives, campaign by NASCOM, innovative measures like setting up toll-free lines to speed up the process of detection have also been launched. PSA and NASCOM jointly helping software retailers, educating computers and corporations, customers and corporations about the negative impacts of piracy. That's a huge issue. FICCI, CII, ICC, they are taking initiatives in organizing numerous awareness programs. CII even created a special IP division, IP facilitation cell. Intergovernmental organizations like WIPO, INTA, ICC, US government, US BTO, doing their best to implement best practices in India. So, let us hope that within years to come, we will also mature in IP enforcement, and it will be a country strong both in law and practice. Thank you.